Alex Murdoch really does not look happy at all at the status conference for how things are going to be going at the hearing on whether he gets another trial.
Yeah, he definitely looks upset. I wonder, do you think he's even going to have a new trial? What's going on with the Murdoch trial? In this episode of About the Law, we're going to be discussing that. I'm Lainey Law.
And I'm attorney Andrew Myers.
What on earth is happening? So, as some of us, maybe you're not as familiar to this case, but he was actually found guilty of murder. And now there's a chance for another trial, saying that the jury was tampered with. What's going on with that?
Yeah, we touched on this a little bit in a previous episode, and the whole internet is aflutter about this. I mean, after 6 weeks of trial and 72 witnesses, a lot of experts, Mr. Murdoch, of course, was convicted in March of 2023 of murder for the murder of his wife and his youngest son, Paul. And it was just, something people watched all over the world. And then subsequently, we covered the fact that his attorneys held a press conference back in the fall of 2023 with all kinds of crazy allegations that the clerk of court, Rebecca Hill, had contacted the jurors and made comments beyond what a clerk ought to be saying. Allegations were that she wants to write a book, which she did, and that she was telling some of the jurors, according to these allegations, which were quite shocking at the time, allegations including her saying to the jurors, well, you watch Murdoch carefully, listen really carefully to what he does and says. And when all of this came out, people were scratching their heads saying, wow, this is just so unusual, so shocking. And, does he really, he was already convicted of murder. Does he deserve a new trial? And many people and commentators and observers were saying, well, even if he was guilty, even if he is guilty, if the things that the clerk said and did are true, American justice and the Constitution really requires that we all get a fair trial. And so, yeah, it was really kind of shocking.
Yeah, and I think that's one of the things that it was nice to hear you say originally when we were discussing this, because the fact at the end of the day is just like, no matter how he was convicted, the main issue at hand right now is whether or not he got a free trial. And
a fair trial.
Yeah, a fair trial. Sorry, misspeak.
Yeah, it's fine.
But because initially when I thought of this whole thing, I was just like, well, this is like a little silly. How is this going to change anything? This isn't really going to change anything for him. But I do think that it is important that, people do have a fair trial and that there shouldn't be jury tampering. And I think that's what this is.
So the defense went into the status conference on this whole thing, feeling that, they were going to present all of this evidence, and the court clerk, Rebecca Hill, was going to be shown for someone who tampered with the jury in order to sell a book, which she did sell a book, which subsequently was taken off the market because it was found that she got an email from the BBC and she sent it along to her co-author. And her co-author, and it's all out there on video, he acknowledges that as soon as he found out that part of the book was plagiarized, he pulled it off the shelves. And I was watching all this, and I actually went on Amazon.com to see, because I like to read books, especially, if I'm preparing to do something like this, I'll buy a book on Kindle and read it really quickly. The book's not available anymore. Kindle and Amazon.com will not sell the book anymore. So if there's anybody in the audience that has the book and they're willing to send it to me, because I just, out of interest, I never bought the book. I thought it was good enough to just see what they said. So now a new judge comes in. She is Justice Jean Toll. She is a retired member of the South Carolina Supreme Court, very learned, very experienced, knows her law, and she came into the picture and set down some really harsh ground rules.
And one of the ground rules that we were talking about, which is, I think, important, like how you mentioned that that book was plagiarized, which I think also kind of puts another perspective on this whole trial, is that they're not going to be able to be asking her about things like that. And they're not
No.
kind of, yeah, it's going to be the judge, I believe, that's only going to be the only one allowed to talk to her and the juries, and that the defense and the prosecution aren't going to be allowed to interrogate them, ask them at anything at all, right?
Well, Attorney Harpootlian and Attorney Griffin, the two attorneys for Mr. Murdoch, really had all these ideas that they were going to just keep going with these allegations. And what did Ms. Hill do, and what was her motivation? And the judge shut them down. And that's why Mr. Murdoch, as you saw in our opening sequence, and you're going to see in a few minutes, Mr. Murdoch was really unhappy because this judge really laid some tough ground rules. And when the attorney said, well, here's how we want to do it, the judge set some very tough ground rules for what she wants to have said and the way she is going to question the actual jurors. Harpootlian and Griffin are not going to be questioning the jurors. She is, and she set down some pretty tough ground rules.
Of what I will be asking them is informed by the question of whether improper contact was made with them and whether it affected their verdict. I understand that you, on the defense side, have views about what further should be asked of jurors on two levels. One, as a predicate to what you want to do with the clerk herself in examining her, and two, as a means of further attacking the credibility of the clerk. But I can tell you that I am very, very reluctant to turn this hearing about juror contact into a wholesale exploration of every piece of conduct by the clerk alleged to have been improper on its own, indicative of her or characteristics or personality or anything of that nature.
So the judge is not going to permit any questions by Attorney Harpootlian and Attorney Griffin about the book. What was her motivation? Did she meddle with the jurors with, the intent of changing things so that she could sell her book? And the judge was very, very, very clear about what the standard is to determine whether or not there will be a retrial in the Murdoch case. And it's a 3-point analysis. And the 3-point analysis is this. 1, did Rebecca Hill, the court clerk, talk to the jurors? 2, was that conduct proper or improper? And 3, if it was improper, did it affect your verdict, Mr. and Mrs. Juror? So that's a tough thing. I mean, that a court clerk talks to a juror, that happens every day. What time do you want your lunch? Do you have diabetes? Do we need to get you your insulin? Do you have child care issues? If you're a smoker, the smoking room is over down the hall. That's the kind of thing a court clerk does. They really just kind of move things along. So that the court clerk had contact with the jurors is not really that relevant so much as whether the conduct was improper. But one more step, which kind of took Mr. Murdoch by a loop, and you can see right there, he's not very happy about it. They have to find out during the questioning of the jurors whether anything that Rebecca Hill said that was improper affected the verdict. And all of the questioning is going to be done by the judge. All of the questioning of the jurors, I should say, is going to be done by the judge. And she's not taking a whole lot of nonsense in this case at all.
I think finding out whether or not it actually impacted the verdict is a really good point. And I think because, at the end of the day, people are people and mess ups are going to happen. But when you're confronted with bias, humans are able to kind of, decide how they're going to be impacted by that. This whole thing, there's a point of it where I don't know, like I understand that it's important to be able to have a fair trial, not free. But at the same time, it feels like this is going to take a bit of time and that there's probably not much that's going to change from this.
Well, if there's an actual trial, you're right. If there is an actual trial, but there are a lot of people out there, and I don't know if I agree with them or not, but there are a lot of people out there that are saying, this judge has towed such a rough hoe that she's going to make it very, very, very difficult. I mean, the jurors have already made some comments in a pleading that was filed by Creighton Waters, the state attorney, and it's going to be a tough road to hoe to get them to acknowledge that Ms. Hill said anything that was improper that made them actually change the verdict. Now, the other interesting thing that I thought was interesting because, frankly, in my practice, I've never gone down this road. I've tried jury cases, I've tried cases, but I've never gone down the road of having a juror be alleged to have had improper conduct from a court clerk. So the inquiry of the jury will be, did what Rebecca Hill say, did that impact your final verdict? Not how did you arrive at that verdict? And the judge, I thought was very interesting, was really clear about that the attorneys cannot even suggest that she ask questions about how they deliberated, what went into their deliberations, what were the factors that they went back and forth on. That's totally off grounds in our American system of jurisprudence. And the way she explained it was that the jury has an absolute right to secrecy and privacy and confidentiality and how they actually reached the verdict. So that's not the question at all. The question for the jurors in this case will be simply, did any of the conduct or contact by Rebecca Hill change the verdict? Not how did you arrive at it, but did it change the verdict? So I thought that was really very interesting. And despite the protestations of Mr. Murdoch's attorneys, Creighton Water, who was the attorney for the state, he was the lead attorney. There were a bunch of them. Made it very clear, and he cited a long line of South Carolina case law pointing out that there has to be prejudice, not just that anything that the court clerk said or did was contact with the jury, but there has to be prejudice. There has to be something that she said or that she did that actually prejudiced them and prejudiced their deliberations. So that was made quite clear. It seems that it's going to be tough for the Murdoch attorneys to prove that there was any improper conduct that, in the third step of the analysis, changed their verdict. So that's what I found interesting.
Even, I guess, my thought is like, because it sounds like the only way that anything's going to happen is if the jury just flat out says that something happened that made that changed their opinion. But at the same time, a lot of the time when we're having these moments where, people are prejudicing us, like making us think a certain way, people aren't even going to realize that that's happening. So it just seems very unlikely to me that even if something did happen, that any of the jurors are going to just flat out say like, oh, you know what, I actually was impacted by this.
Yeah, I think they would have to be pretty frank about that. And I think it's almost an impossible standard because you're almost asking them to admit that they made a mistake. And what human being wants to admit they made a mistake? It would almost have to be something to the effect of, at one point the allegation was that Rebecca Hill, the court clerk, said something, these aren't the exact words, but something to the effect when Mr. Murdoch was going on the stand to testify, well, you watch him, keep a close eye on him, listen to what he says. I don't think she came right out and accused him of being a liar, but she came pretty close to that. So one of the jurors would actually have to come out and say, yeah, because Becky Hill told us to really watch him carefully, I was looking right straight into his eyes. And, when I reached my verdict, because of what she said, I went along with it. So it would have to be almost that clear of a thing. And whether that's going to happen, I have a really hard time believing that. There was a little side issue here. And that was whether the motion for the retrial was brought in a timely manner. In other words, The conviction of Alexander Murdoch came in early March of 2023, and attorneys Harpootlian and Griffin didn't actually bring their allegations and file their court papers requesting a retrial until September. So that was a long time, but I looked up the South Carolina rule, and if it's something that happens during the trial that you think is plain error, you got to bring that motion within 10 days. But in a situation like this, where it's newly discovered evidence that couldn't have been discovered through due diligence previously, what the South Carolina court rule says is that a motion for retrial has to be brought in a reasonable time. So the judge brought this up. Judge Toole brought this up that, there's a question of whether it's timely, but I don't know if it was dropped or they just went on to other matters, because the judge went on for a very lengthy period of time laying out ground rules and discussing how things are going to go. And so it would seem to me that the idea of the thing being brought in an untimely manner is water over the dam, because they've already set a date for Alexander Murdoch's hearings on January 29th, 30th, and 31. So this is the case that just won't go away.
I mean, timely 10 days versus months is kind of crazy, and it's kind of interesting that was moved past too. I don't like I know it's just bizarre to me, because it's just like, what changed in those months that really made it a case to bring out now? But then on top of that, it's just a lot of, he said, she said, it seems like, and I don't know. It doesn't look good months after the case. I
think the reason for the delay, and I'm not defending anyone, but just to kind of address the concern that you just raised, was that apparently there were some rumblings of what nature. I don't think anybody knows exactly, but there were some rumblings of maybe Mrs. Hill said this or did that, but everybody dropped it. The verdict was in, and when a jury renders a verdict, that's 99 times out of 100 the end of the case. But what happened is that she then published a book about the Murdoch trial. And although there's no clear law saying thou shalt not write a book while you're still sitting in your job right immediately after the trial, it just left a bad taste in a lot of people's mouths. It didn't really pass the smell test, as a lot of people say. And that's when I believe what happened is a couple of jurors had already gone on the Today Show. I mean, I remember watching it way back in the spring of 2023, sitting there drinking my morning coffee, trying to wake up, and I'm like, there were 3 jurors. There were 3 jurors on the Today Show. But a couple of jurors actually, when the Hill book came out, allegedly are said to have come forward and said, it doesn't really sit right with us that she came out with a book that quickly after trial. And then we remembered that she said a couple of things to us during the trial, and Harpootlian and Griffin, I believe, had an investigator go talk to them, because there were, in fact, affidavits that were submitted in court saying that there had been this improper conduct. So that's, I think, that's their version of why it took so long. It's going to be really very difficult for them to overturn this verdict, just because it's very difficult to overcome a jury verdict to begin with. But based on the rules that this judge has set up, she said that the attorneys in the room will not be questioning the jurors. She's the only one that will question the jurors. The jurors will not be appearing in front of the camera. Court TV is going to do the televising of this court matter. Pay attention in Idaho. That was uncalled for. I apologize. But the court TV photographers will be instructed, you will not show pictures of the jury. And that's fairly standard in any case. And the jurors will not be referred to in open court by name. They will only be referred to by their number 638 or I-23. The jurors' attorneys were actually there for this hearing, and they wanted this all to be done behind closed doors. They wanted this all to be done, in camera, as they say, in the judge's chambers. But the judge says, no, we're going to do it in open court. No focus. I'm just reading my notes from the hearing. You'll be referred to by numbers only, the jurors. No focusing on the jurors. Everything will be in open court. the questioning will only be by the jurors who actually deliberated. So the egg lady's out, no egg lady, and the jurors who sat through the trial but did not deliberate, they will not be allowed to be questioned because they were part of the deliberations, and so any improper conduct did not affect them in that they were not the ones that deliberated and reached the final verdict. So I thought that was interesting. And Harpootli and Griffin were not happy with that idea because they thought that maybe these alternative jurors could bring in corroboration as to what the conduct by Court Clerk Hill was. Judge Toll was having none of that, and she snapped back very forcefully and clearly, and she said, "I'm a good judge of conduct and conduct and character, and I don't need any corroborative testimony." So she shut them down on that. She shut them down very clearly. Also, some things that happened, and I'm just again reading from my notes from watching this hearing. The court will not subpoena witnesses if Murdoch and the state want witnesses. The attorneys have to work together to do the subpoenas of witnesses because the judge doesn't want any part of that. I thought this was an interesting thing. Judge Toll says that Becky Hill will not be allowed to take the Fifth Amendment. And I thought that was crazy because that's one of our basic constitutional rights.
For people that might not understand, what do you mean by not being able to take the Fifth Amendment?
Well, that just means you don't have no American citizen can be compelled to testify against themselves. In other words, if you're if you are in an interrogation, you have every right to say, "I want a lawyer," or "I do not want to make any further I do not want to make any further comments." The Fifth Amendment affords every American the right to refuse to testify against themselves. So if push comes to shove and one is being asked a zillion questions, you have a right to say, "No, I assert my Fifth Amendment right." So the reason Judge Toll says that Rebecca Hill will not be allowed to do that is because she's already submitted an affidavit. She's already given her side of the story in an affidavit that was presented by the prosecution. So if she's already presented her side of the story in her affidavit, the defense should certainly be allowed to cross-examine her, and she can't take the Fifth. That is an open question, because that's what the Supreme Court, the retired Supreme Court Justice of the South Carolina Supreme Court said. Justice Toll, she was a judge. I was not a judge. She knows the law in South Carolina. I don't know the law in South Carolina. But to a lot of people, not just me, a lot of commenters have said, does a judge have the right to tell a witness that they may not take the Fifth Amendment? So that's an outstanding question. Other notes that I have from the hearing are that the judge will ask all of the questions to the jurors. The attorneys can indicate if they have others. She will ask them. She'll ask them when she's done questioning the jurors. She will ask the attorneys if there are other questions, and at her discretion and her discretion only, the judge will decide whether or not she would like to ask additional questions. When it comes time to Rebecca Hill and any other witnesses, the attorneys will be allowed to ask them questions and do the questioning in that case. But, you know, I think that based on what we have seen in this hearing, I believe that it's fairly clear that she's going to keep a pretty tight control over the hearing. So it will be interesting to see what happens in this case.
And not to kind of distract from the subject, but if you guys heard a loud noise, that is Lily the office dog is in today.
Lily the dog.
We're gonna have to get a little picture of Lily in the channel at some point. Yeah, the whole thing just sounds a little bit crazy. I mean, oh, actually, Lily, you know what? All right, for the viewers at home, there she goes.
Show us her again. Let me put you on full screen so they can see Lily the dog.
There she goes.
There she is.
Yeah.
She's eating her lunch.
She's eating her lunch.
Lily's busy eating her lunch. All right. Okay. Thank you, Lily, for helping
our
us along.
Special guest,
here.
yeah. our Fifth Amendment law expert. She doesn't do a lot of talking here. It is weird to me that you can't just choose to like stop though. Like, I don't know. I think like I agree that, I mean, she's already said her part, but at the same time, you would think that you could just stop saying anything at any point.
Well, Judge Toole, had a lot to say about how far the attorneys were going to be allowed to go. The attorneys for Mr. Murdoch, I mean, they really are grasping at straws. I mean, they really want to do everything they can to get this man another trial. Why, I don't know, because the evidence, which we can get into if you want to, but I think we've been over it so many times. She just doesn't want to turn the hearing as to whether or not there should be a second trial into a long, drawn-out exploration of everything that the court clerk is alleged to have done. She doesn't want to get into the book. She doesn't want to get into her motivations. She said, and these are my notes, these aren't the judge's words, but she said, "I don't think it's necessary or proper to explore every impropriety or alleged impropriety by this witness, Rebecca Hill. The focus in this case is on the jury, on the impropriety, and whether, most importantly, that impropriety and the contact by the court clerk impacted the jury verdict." So she said that a bunch of different ways at a bunch of different times. So this hearing is going to be laser focused on that topic, and there's not really going to be a lot of getting away from that. And again, she repeated that Hill's motivation is irrelevant. The only thing that's relevant in this trial is, did Rebecca Hill have improper conduct with the jurors? Did that was that contact proper, and did that impact the verdict? So it's as simple as that. I can't even see how this is going to go for 3 days. The hearing is scheduled for 3 days, but I don't see how it can go. Even if they bring all 12 of the jurors in, how long can that go? And even if they bring Rebecca Hill in, how long can that go with all the limitations on what the judge wants to say? So, I mean, I of all people know that, attorneys have a way of talking a lot. But I can't see it going 3 days unless they don't start until 10 and they take a 2-hour lunch and they're done at 3. I mean, in any event, that's how it stands at this point.
Yeah, I think the whole book thing is wild. I think that if the stuff about the book, the plagiarized book, was allowed to be included, I think that there would have been a chance for this to come out very differently. But the fact that it's all in the hands of the jurors to basically say, that their opinion was changed in one way, shape, or another, that would have impacted the verdict. I think that is going to be really hard to prove.
That's a whole different topic. That's a whole different subject. Whether the book was, it's, in my way of thinking, it's a horrible thing. I mean, she actually, first of all, in my opinion only, but it's shared by a lot of people, should somebody that's still got a job be profiting off of a book when they were observing things as part of their job? Now, take it to presidential politics. After certain presidents have resigned or died, people come out of the woodwork and talk about them. Look at all the books that came out about Clinton. Look at all the books that came out about Nixon. Good grief. Tons of books. Look at all the books that did come out about the George Bushes, both of them. But generally speaking, people like secretaries of state and cabinet members and, people like that, they generally speaking, and it's not a rule really, but it's kind of a social mores that they kind of wait until the administration is over. They retire. They retire into their den and their word processor. And then at that point, they start writing their books. And sure, they're in retirement and they're probably making huge pensions at that point anyhow. But at that point, sure, let them write their book, let them write their memoirs. But so from the very beginning, or ab initio, as attorneys like to say, it just seemed a little bit odd that she wrote a book so quickly. But then, when it came out that apparently she had received an email and she just sent it along to her co-author, who I think was really the shadow author, he didn't know. So he put it right in the book. But the minute he found out about that, according to an interview that he did that I saw, he just shut down the book. And, again, I went on to Amazon.com to see if I could buy the book. No longer available. So that's that. Now, you might ask me, gee, what do you think's going to happen? Do you think that he will get his retrial? And I'll answer that in two ways. I never give odds. My clients always ask me, every time they say, what are our chances? What are our odds? And that's, I don't lay odds. That's number one. But number two, the judge laid down a hard line in this hearing the other day. She laid down a really hard line. And so a lot of the prognosticators are saying, he's not going to get his second trial. He's just not going to get it. She's put the bar way too high and nobody could ever meet that. On the other hand, I bet other attorneys who are watching this will have had the same experience. A lot of judges have a poker face. I've gone in front of judges and they gave me a really tough day. They've given me a really tough time. They've peppered me with questions. And I've walked out of there almost with my head in my hands thinking, oh my God, I lost this one. And lo and behold, you won it. And I've had the converse experience. I've had what I thought was a great day in court. All my evidence went in and my argument went in and the judge seemed to be listening and it seemed to be my day and then I didn't do so. So a lot of judges have a poker face and they will try to overcompensate and they'll try not to. So whether that's the case here, I don't know. Nobody out there, none of our viewers know what's going to happen. But I don't think it's even appropriate to jump ahead to the next question. Let's pretend he gets a second trial. Is it going to make a difference? In my view, no, of course not. Of course, it's not going to make a difference because, what about the Bubba tape where, 6 or 7 different people recognized that it was his voice down at the dog kennel when it came time just bore the actual murders were said to have happened. He had this alibi that, I was inside sleeping on the couch. Then I went and I visited my mother. Nuh-uh. There was a video. It was a Snapchat on Paul's phone that they dug out. And they were talking about one dog's tail. And you hear Maggie's voice saying, look, Bubba's got a chicken in his mouth. Well, he didn't have a chicken in his mouth. It was a quail, I think. 6 or 7 different witnesses said they knew for certain. There was no doubt. Don't even talk about reasonable doubt. There was no doubt in their minds at all that was Alexander Murdaugh's voice down at the dog kennel where the murders took place right before the exact time of the murders. So that tape croaked him. And the other thing that croaked him, in my opinion, and the opinion of a lot of observers, was that he went on the stand and said, I'm a liar. I lied because I was on these drugs. No, you don't go. No, you never go on the stand and admit you were a liar, in my view. And I think the view of a lot of people out there, he croaked himself. So he may well get a second trial. Most people think it's doubtful. But even if he does get a second trial, I never lay odds, but it's just the evidence was so horrible in that case. The evidence was so horrible, and it only took the jury just under 3 hours to deliberate and find him guilty. So, Mr. Murdoch, he's already pled guilty to a bunch of financial crimes, and so he's going to be in jail anyhow on those for 27 years. So he's in his 50s, and 27 years is a long time. So that's pretty much all I have to say about that. What about you, Lainey? Any closing thoughts here?
It's a mess. It's a disaster. Like you said, do I think anything's really going to change? No, but I am interested in seeing where this is going. The whole book thing, as good as it probably is to be separated from this whole deciding to jury was tampered with. I can't get that out of my head. It's just the most ridiculous, unprofessional thing that I've heard of in a while. So it's going to be interesting to see where this goes. But I don't know. I don't think anything's going to change.
Yeah, if you're going to write a book, write the book. Now, a lot of people hire a ghostwriter because a lot of people are not very good at writing. A lot of people have writer's block. A lot of people just don't like to write. A lot of people just are afraid of writing for whatever reason. That's fine. Hire a ghostwriter. A lot of people ghostwrite stuff. I've ghostwritten stuff. But if you hire a ghostwriter, be honest with that person. Don't send them a bunch of rubbish, or don't send them something that someone else wrote, because that's one lesson that we can all learn from this. among others. But I'm going to take your job and tell people to please subscribe and like, and we hope that they've enjoyed this podcast, and we will be following this. Do you have any closing thoughts?
No, I mean, just don't use ChatGPT to write your books. Stay honest and have a wonderful, beautiful day, guys.
Have a good one. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions.
And that's that.